The court will hear closing arguments from Mr. Sanders on behalf of his client, Mr. Eyman. Mr. Sanders?
Thank you very much, Your Honor. It seems to me that although this case has a lot of documents, exhibits, depositions, several days of testimony, that the really important facts from the standpoint of the defense are not really disputed or contested. One deficiency I saw in the argument from the state is adequate discussion of the statute. The statute, and only the statute in the constitutional context, controls the disposition of this case. Therefore, it's important to recognize exactly what the statute says, and perhaps more importantly, what the statute doesn't say, and to understand the statutory scheme. Now, there are two essential fact patterns in this case associated with the state's claim. The first is reporting requirements pertaining to I-1185 and I-517 occurring in 2012. The other important aspect of the case is the claim that Mr. Eyman is a continuing political committee because he solicited gifts from friends to pay his personal and family expenses. That's the second subject matter. So in that regard, I will also want to discuss this court's September 13th, 2019 order for non-monetary relief, which was the sole basis of the court's partial summary judgment, characterizing Mr. Eyman as a continuing political committee, and also ruling that he received contributions as a continuing political committee in the amount of $766,000 over the course of 6 or 7 years. Finally, I think it's helpful to recognize that the propriety of all of Mr. Eyman's activities over the last 20 years is not really an issue in this case. It is whether he did something during the course of the statute of limitations that would be after March of 2012, which violated the statute. That's the only issue. And depending on the court's resolution of that issue, then I think we have to consider whether the statute as applied is unconstitutional. But the statute, nevertheless, is the guiding light of this proceeding, and we should focus our attention on that. As to the first general subject, let's discuss I-1185. And I don't think we can discuss that without discussing the duties of the treasurer, Mr. Stan Long. There's no dispute that a political committee by that name was properly filed and formed by the treasurer, Stan Long. There is no dispute that the officers of that committee were Mr. Eyman as well as Mike and Jack Fagan. There's no dispute that Treasurer Stan Long was a highly qualified individual. He was a lawyer, a CPA, a former IRS agent. I would say that no one could be better qualified to serve the role as a treasurer. There's no proof in this proceeding that there was ever a complaint against Mr. Long, and indeed he has unblemished expertise and integrity on this record. So the sole duty to report under the statute is that of the treasurer. And whether you, and however you characterize the treasurer, that doesn't change the statute. RCW 42-17A-210 requires a treasurer to be appointed as really the first step in organizing a political campaign or a political committee. The treasurer, section 220 provides the treasurer must deposit contributions in a designated account, and only the treasurer. Section 235 says the treasurer must file all required reports in a timely fashion. A treasurer must certify all reports are true and correct. A treasurer must disclose each loan to be made to the committee with the name and address of the lender. There's no requirement, in fact, it's not provided for in the statute at all, that loans made to other than the political committee need be disclosed. There's no requirement in the statute that the source of the funds to the lender need be disclosed. The statute is predominantly only a reporting statute. It allows the treasurer to file these reports, and ironically, evidence in this case shows Mr. Eyman's attempts to file an amended report regarding the data bar incident was rebuffed by the PDC precisely because Mr. Eyman was not a treasurer. Evidence in the case shows that the PDC has in the past commenced actions, enforcement actions against various treasurers of various campaigns. For example, in 2002, the PDC started an action against Suzanne Kerr, who was associated with Mr. Eyman's campaigns at that time, and eventually got a judgment against her. The same thing happened in 2017 against Barbara Smith. I'm not quite sure how that turned out, but certainly the PDC was attempting to hold Barbara Smith accountable as a treasurer for some reporting error. So the duties of the treasurer are the same, whether they're ministerial or not. The statute doesn't make a distinction there. And Barbara Smith is an example of a ministerial treasurer who was on the receiving end of an enforcement action by the PDC. So, of course, a fundamental basic fact, not contested, is that Mr. Eyman was not a treasurer for any of these campaigns. And in fact, he had no legal ability to become a treasurer because the state had obtained a judgment against him being a treasurer or acting as a treasurer. So the first legal point is this. Mr. Eyman has no duty to report anything and is legally prohibited from reporting anything. Therefore, he cannot be liable if something was misreported by the treasurer. Having said that, however, Your Honor, we're not trying to blame anything on Mr. Long. We think Mr. Long did a perfect job in acting as a treasurer for the two campaigns at issue, that is 1185 and 517. Exhibit 145 are the reports actually filed in the 1185 campaign. These reports were signed by Stan Long. C1PC form is the registration of the committee, which is proper in form and timely filed. Form C4 is the summary full report of receipts and expenses, which was timely and properly filed by Stan Long. Schedule A to that detailed cash receipts and expenditures was timely and properly filed by Treasurer Long. Schedule L lists, and I quote, the lender's name and address, close quote, as Tim Eyman due to a loan Mr. Eyman made to a previous or a predecessor campaign. Under the statute, you can roll over these loans to a replacement campaign. That reference is illustrative of another issue in this case, and that is that Tim Eyman was listed as the lender. There's no place to list how the lender got the money that he loaned to the committee. And as a matter of fact, it's not listed, but it is true that Mr. Eyman borrowed the money. And that was a perfectly legitimate way of reporting the transaction. Schedule C3 asks for monetary contributions. That was promptly filed by Mr. Long as well and is accurate in every detail. Generally speaking, these forms were to be filed every month over and over again. And they were filed in a timely manner. I believe the rule is that it's sometime they're to be filed sometime after the first of the month with a deadline of the mid-month, but it's up to the committee when they actually want to file the report during that time frame. On April 2nd, 2012, Mr. Long filed an amended registration to change the name to save the 2/3. This was all proper. So the bottom line here is that these reports were accurate and timely filed by the treasurer. So we're talking about a signature gathering vendor. There were other vendors as well. All payments to the to Citizen Solutions were reported in these filings. They were accurate and they were properly dated. The claim is by the government, I think, that how Citizen Solutions spent its money is somehow reportable, but that is not supported by the statute. The campaign committee reports expenditures to Citizen Solutions, but does not report how Citizen Solutions spends its money. And by the same token, there is no obligation on Citizen Solutions to report how it spends its money either. So whether or not that's a good idea, I don't know, but it's a question to be addressed to the legislature. And it is a question that has already been answered for the purpose of this lawsuit, the court, myself, and it should be answered in that way by the Attorney General as well. Unlike a candidate for political office who is required by law to file a Form F1 pursuant to Section 700 and 710 of the statute, no statute requires an officer of a ballot measure committee report his personal financial transactions. So there's a difference there. And there's a reason for the difference. The statute requires only campaign receipts and expenditures be reported by the ballot measure committee, but has a much broader personal financial reporting requirement when it comes to a candidate for public office or one that occupies public office. There's a reason for this. A successful candidate will continue in office and may be corrupted by past or future financial dealings. That's the theory why it has to be reported. However, a ballot measure is a single statutory enactment, the enforcement of which or the application of which is not subject to any influence or control by the persons who proposed or promoted the ballot measure. Hence, there is no reason why the public should require those individuals to file a financial disclosure report about their own personal finances. And I think that this is a distinction which is important to understand what's in the statute, what's not, and what's, more importantly, for our purposes, not in the statute. Now, the state has come up with a 20-year conspiracy theory involving multiple individuals, some of whom were not even parties to this case, a conspiracy to somehow divert money to Mr. Eyman under the table and to defeat the purpose of the political committee. The linchpin of that theory appears to be that the 1185 committee inflated money paid to Citizen Solutions to gather signatures to allow a kickback to Tim Eyman, which was not reported. So the state's claim, in my view, has two problems. First, the statute does not prohibit the alleged conduct, nor require its reporting. And second, the state has not proven the alleged fact that any payment to Citizen Solutions for signature was inflated. All right. First, the statute. The statute does not regulate what a political committee may pay its vendors, a vendor including a signature gathering firm or otherwise, only that it report it. Nor does the statute regulate what transactions may transpire between a committee officer and a vendor, nor does it require that that be reported. So if everything occurred exactly as the state claims, it would not violate the statute. The statute simply doesn't regulate the relationship between a committee officer and a vendor. The statute must be clear for guidance to all campaign treasurers. If it is not clear, if it is ambiguous, if it is subject to various interpretations, it fails as a unconstitutional, vague statute. It has penalties. And this vagueness doctrine, I'll discuss it more later, but it was referenced in the leading case, Buckley versus Vallejo. The statute must require in unambiguous terms what must be reported, i.e. campaign contributions and expenditures, and what not need be reported and cannot be reported, e.g. transactions between committee officers or vendors. Nor do the facts support the state's theory that the prices were inflated. No facts, let alone a preponderance of evidence, support the proposition that the price paid to Citizen Solutions was, one, inflated, or two, that it was based on a possible future consulting agreement between Watchdog and Citizen Solutions. In pretrial proceedings, by the way, Your Honor, your image has disappeared from my screen. I don't know if that's important or not. The state, in pretrial proceedings, the state claimed the fair market value of signature gathering in this instance is not relevant to its theory, and actively sought and obtained an order in limine preventing Mr. Eyman, my client, from introducing evidence to the effect that these prices were at fair market value. Therefore, I think it is a fair inference that Citizen Solutions was paid a fair market price. So their theory of liability must go elsewhere. If it's the state's theory that the two negotiated price per signature bumps late in the campaign were accomplished to line Mr. Eyman's pocket, the facts not only don't prove it, but disprove it without contradiction. The evidence regarding these two price bumps, one for 50 cents, one for $1.50, includes emails, testimony from Mr. Eyman, and deposition testimony from Mr. William Agazarm, and all of that testimony is uncontradicted in the record. As to the emails, several emails discuss a proposed 50-cent increase to the price paid for signature gathering. Exhibit 502, also Exhibit 82, is an email from Eddie Agazarm, dated May 15th, 2012, to Mr. Eyman, suggesting and justifying a 50% increase due to market conditions. The concern raised in the email is that unless the price paid per signature gatherer was bumped up by 50 cents, there was the prospect that they might not be able to get the sufficient signatures to qualify the measure for the ballot. This price bump was not justified in any document or by any testimony in this case, to pay Mr. Eyman any more money than he would otherwise be paid. Exhibit 504 includes an email from William Egazarm to Mr. Eyman dated also May 15, 2012, which was fully and voluntarily disclosed to the PBC, which also justified a 50-cent price bump by market conditions and stating, quote, "And just so you know, we won't make anything from the bump. All of the extra will go to the coordinators and petitioners to get I-1185 over the finish line," close quote. Nothing in the record contradicts any of this, and this was forwarded to Mr. Greg Hannon as well in the interest of full disclosure. And I'd refer the court to Exhibit 529. Exhibit 503 is an email from Eddie Egazarm to Mr. Eyman saying an additional $1.50 was needed due to I-1240, that is this Charter Schools Initiative campaign, paying signature gatherers double what 1185 was paying. This fact was also forwarded to Mr. Hannon to keep the lobbyist fully informed of the circumstances. Nothing in the record contradicts anything in this email. Paying Mr. Eyman was not a reason for the bump and was never even discussed. The state's only substantive witness on this issue was Tony Perkins, who had no testimony on this subject, nor did he have any opinion on the fair market value or reasonableness of the amounts paid signature gatherers. The state had previously identified an expert to testify on this subject, Angelo Paparello, who was deposed by Mark Lamb, my predecessor lawyer. After the deposition, the state decided not to call Mr. Paparello to testify to inflated payments. The state presented no evidence to support its claim. Probably they didn't call the expert witness because the expert witness's views would not support the state's position.
Objection. Facts not in evidence. There's a discussion on this.
Sustained.
So move to strike.
Motion to strike is granted.
Well,
Please
I
continue.
was arguing that it's an inference, Your Honor. If that's,
Understood. Understood.
Mr. Eyman testified that the only reason to bump the price was for market considerations and was unrelated to a subsequent consulting agreement with Citizens Solutions. He testified in open court after submitting to a lengthy deposition and multiple statements under oath. He was available for the state's cross-examination. I do not recall any effort to impeach Mr. Eyman on this particular subject. The other witness offering testimony through a deposition was William Egazarm. In his November 27th, 2018 deposition, pages 53 to 55, that the $308,000 payment for the consulting agreement had nothing to do with 1185 payments to Citizens Solutions, but was to secure future work for Watchdog over the next 3 years to solicit new business for Citizens Solutions. So in order for the conspiracy theory to fly, I think that there is a chain or that there is a link missing in the chain of evidence, and that is showing a substantial relationship to the price bumps and to the payment to Mr. Eyman. Now, there's a number of, not only do the witnesses testify contrary to that view, the state has presented no evidence in support of that view, but the additional revenue received from the price bumps does not come anywhere close to the $308,000, which was the subject of the consulting agreement. Citizens Solutions stated all additional revenue from the price bumps went to signature gatherers, and two, that additional revenue from the price bumps was not $308,000 or anything close. Recall 50% increase in mid-May per signature for 200,000 signatures, which was the estimate, equals $100,000. Later, in the course of the campaign, the signature price was bumped by another $1.50 for the last signatures, approximately 40,000 signatures, and that equals $60,000. Therefore, the price bump netted, in the sense, or grossed, I would say, Citizen Solutions $160,000, nowhere close to the $308,000 contract payment to Watchdog, which was subsequently negotiated. Now, the consulting agreement between Watchdog and Citizen Solutions was not reportable under the Fair Campaign Practices Act by the 1185 committee, Treasurer Stan Long. Although there was no reason for it not to be disclosed if it was required by the statute, but it simply wasn't. There is no provision in the statute which requires the reporting of a transaction of how a vendor spends its money by the campaign which contracted with the vendor. Mr. Eyman had no independent duty to disclose this, although he would have if he had that duty. Mr. Eyman did report this consulting contract to the IRS, and he paid taxes on it. He freely and fully disclosed everything about this transaction to the PDC when asked, as admitted by Tony Perkins during Mr. Perkins' testimony. Mr. Eyman submitted to a statement under oath, which Mr. Perkins said answered all of his questions in this regard. And that statement under oath was taken substantially before Stan Long tragically died in an auto accident, although no one from the PDC attempted to contact Mr. Long to get his version of events. In summary, Your Honor, there is no evidence that, number one, signature gathering prices were inflated, let alone, number two, inflated to pay Mr. Eyman a kickback. But even if they were, this does not violate the statute, nor is it reportable under the statute. This is where we have to look at the statute and read it carefully and realize that the statute doesn't cover everything, especially when it comes to ballot measure campaigns, and that people cannot be held accountable for what the statute does not require. If the court or the Attorney General believes the statute should require this, then the place to go is the legislature and make the case. Next, the loan to citizens in charge did not violate the statute. The facts are that shortly after the receipt of the $308,000 from Citizen Solutions, money that was the property of Citizen Solutions that they had earned as a profit, Watchdog loaned approximately $200,000 to another organization, Citizens in Charge. Mr. Eyman used the rest of that money from Citizen Solutions for his personal expenses. This is not the payment of some of this money for personal expenses does not violate Section 445 because these were not campaign contributions that he received, but were rather funds paid by Watchdog to citizens, funds paid, but rather were funds owned by Citizen Solutions paid to Watchdog. This was Citizen Solutions money, which it had the right to do anything it wanted to and had no reporting requirement. After they paid the money to Watchdog, it became Watchdog's money. This act does not prohibit Citizen Solutions from making a profit, nor does it direct how that profit must be spent, nor does it require a campaign committee or a vendor to report same, period. That's in the statute. Nor does the statute require Watchdog to report its $200,000 loan to the citizens in charge. Watchdog is not subject to any reporting requirement. As illustrated by I-1185 filings and forms, only loans to a political committee, not a third person, need be reported by the political committee. Even if one's loans to a political committee needed to be reported, the source of the loan need not be reported, as illustrated by the loan Mr. Eyman made to the predecessor committee to 1185. And this is also uncontradicted in the evidence, as this was in fact a loan with the expectation of repayment, and that over $100,000 of the loan was actually repaid by citizens in charge to Watchdog. So it was a loan. And that's significant because the statute treats loans differently than contributions. Although the specific funds loaned to citizens in charge by Watchdog cannot be specifically traced to in-kind expenditures for the 517 campaign, even if they could be, there is no requirement that a political committee disclose the source of the contribution of a lender, let alone identify the lender. If a loan was made to directly to 517, the lender need be identified, but not the source of the lender's funds. And that was illustrated by the earlier campaign that I talked about. Whether the lender was a commercial or a person does not matter for the purpose of reporting on a ballot measure, although different requirements pertain to candidates who are subject to contributions limits. And that's specified in section 465. So it doesn't matter whether it's a commercial bank, it doesn't matter whether it's Watchdog or some person or something else, it need not be reported. If there were a requirement in the statute, loans to a contributor must be reported. That is, loans to a contributor. Mr. Long would have done so. Mr. Long had full knowledge from Mr. Eyman and Paul Jacob of Citizens in Charge. That was their testimony. I-517 reports are contained in Exhibit 140. They were prepared by Mr. Long. They were timely, full, detailed, and accurate. They disclosed every single in-kind contribution from a citizen in charge and everyone else to promote the I-517 campaign. Mr. Eyman bore no responsibility for these reports because he was not the treasurer. However, Mr. Long's work product cannot be faulted. This is not concealment prohibited by section 435, because this section does not require a political committee to disclose the source of a loan made to a contributor, even if the loan is for the express purpose of funding a contribution. I previously gave the example of the report in 1185 that Tim Eyman made a loan to the predecessor committee with using borrowed money. And it was properly reported by 1185 that the lender was Tim Eyman with no discussion of where he got the money. And that's what the statute requires. All in-kind contributions to the 517 campaign were admittedly improperly reported as in-kind contributions from citizens in charge by Treasurer Stan Long. There's no dispute about this. The statute could have provided otherwise, but the legislature elected not to put that in the statute. The record also shows without dispute that Mr. Stan Long was fully aware of the loan, according to the testimony of Mr. Eyman, that he and Mr. Jacob and Mr. Long had lunch together and talked about all of this. Mr. Jacob testified about the lunch and a man matching the description of Mr. Long. That's in the Jacob deposition of February 3rd, 2020, pages 56 and 57. Mr. Eyman, in his testimony, identified that the individual that Mr. Long had attended that lunch, and that, as Mr. Jacob testified, all of the circumstances regarding the loan were fully discussed at that time. So the state had ample opportunity to interview or depose Mr. Long, but it didn't, perhaps believing that Mr. Long would support Mr. Eyman's version of the events. Once again, Mr. Eyman had no duty or authority to report anything. However, Mr. Long fulfilled his duty under the statute in any event. He reported all contributions to and expenditures from the I-517 campaign in Exhibit 140. It's right there. That's one thing the state never talks about, is we have these two exhibits with all the reports actually filed. It never tells us how those reports should have been different by its own theory. Are they saying that payments to citizens in charge should not have been reported, or that in-kind contributions from citizens in charge should not have been reported? If that's its position, that's counterintuitive and appears to be inconsistent with the statute. Apparently, the PDC was predisposed to pursue Mr. Eyman, and did not bother to discuss the matter with Mr. Long, who had no interest except to fulfill his reporting duties, and was as competent a professional in such matters as anyone can find. The state's reporting claims for 2012 have no basis in fact or law, and therefore must be dismissed. The second broad subject matter of the complaint is Mr. Eyman as a continuing political committee. In this area, it is very important that the court read the definitions and other provisions of the statute pertaining to this claim. Unrelated to the above, the state's amended complaint asserts Mr. Eyman is a continuing political committee and did not report, quote, political contributions and expenditures, close quote, subjecting him to civil penalties while leaving the door open for criminal penalties. Briefly, the facts are that Mr. Eyman solicited his friends to provide gifts to his family for living expenses and for legal defense. The state claims the former must be reported, but not the latter. There is no claim by the state that Mr. Eyman expended any of this money on any electoral campaign, nor that he represented that he would. I think that's a critical fact. The money was solicited for personal use and used for personal expenses, and nothing went to electoral campaigns, nothing. Although this is really a legal question of whether an individual seeking funds for his living expenses is properly cast as a, quote, continuing political committee, close quote, it may be important to recall all of Mr. Eyman's solicitations since his bankruptcy in November 2018 had been for legal defense, for the Legal Defense Fund, which is non-reportable under the state's theory. Prior to the bankruptcy, he did solicit contributions for his personal expenses, but since then it's been only for legal expenses. The state's theory that solicitation of gifts to pay personal expenses seems to relate back to Mr. Stutzman's letter of August 13th, 2002, which is Exhibit 177. As made clear in the follow-up letter, which is Exhibit 178, Mr. Stutzman seems to opine donations to Tim as a political activist for his personal expenses must be, quote, political contributions, close quote, because he may promote a ballot measure through his personal efforts, such as speaking, wearing a gorilla suit in the Capitol, getting on TV, etc., even though he never uses the money in an electoral campaign. According to Mr. Stutzman, Kim can have a legal fund, but not a grocery fund. Although the state listed Stutzman as a witness, it did not call him, where he could be cross-examined on his bizarre legal theory.
Objection, improper argument. Mr. Stutzman was equally available to the defense.
Court will overrule the objection. Please continue.
Mr. Perkins was asked about the letter, asked to justify it, and he could not do so. So when counsel says that there's some significance in this letter, I think that the significance is that the state apparently got this theory out of thin air and then spent the next 20 years trying to apply it to Mr. Eyman. But there's no basis for the distinction drawn in the Stutzman letter. In any event, at that time, Mr. Eyman was primarily concerned, had been raising money for legal expenses. He just had a judgment taken against him. And he was not raising money for personal expenses. So the personal expense aspect of it was really not relevant to what Mr. Eyman was endeavoring to do. Now, in point of law, soliciting gifts from friends to support an activist's political advocacy do not make that person a, quote, continuing political committee, close quote, because those contributions are not, and I quote, in support of any ballot measure. And I'm referencing here the definition of a political committee contained in RCW 4217A 005 subpart 40. They are in support not of a ballot measure, they are in support of Tim Eyman. And Mr. Eyman is not a ballot measure as defined by section 005 subpart 4 as, quote, any initiative proposed to be submitted to the voters of the state. Mr. Eyman is not an initiative proposed to the voters of the state. Political contributions are, quote, contributions in any election campaign, close quote. And I'm looking at section 205, parent 1 parent. It's an election campaign. That's what the statute is about. And political advocacy is not an election campaign. If Mr. Eyman wants to advocate that people sign some initiative, that is not an election campaign. That is Mr. Eyman exercising his free speech rights of advocacy. I think that there was further enlightenment on this particular point in the state versus grocery manufacturing case. That is 195 Washington 2nd, 224, paragraph 30. And I quote, as our trial brief quoted, by the FCPA's plain language, the contribution prong does not apply any time an organization receives any funds that could potentially be spent in elections. It applies when an entity has, quote, the expectation of receiving contributions to be spent in elections, close quote. So I think that that just blows the state's theory right out of the room because the contributions, the expectation of Mr. Eyman in receiving those contributions was not to have them spent in elections. It was to spend it on himself. So I think that the state's interpretation of this is off the wall. Now, and I'll admit that none of the funds were, in fact, spent on elections. Under cross-examination, Mr. Perkins was unable to identify any precedent which has ever characterized an individual raising money for his own support as a political committee, much less a continuing political committee, which is the state's claim in this proceeding. A continuing political committee must fulfill the a language regarding the expectation of receiving contributions for an electoral campaign, but also it must be an organization, not an individual. That's in section 005, parent 14, post parent. So I think the claim on the merits that Mr. Eyman is a continuing political committee is far from the mark. And unfortunately, the court based its summary judgment on the court's order for non-monetary relief entered on September 13th, 2019. And we asked that the court revise that order. Now, that order was entered at a time when Mr. Eyman was pro se. He was defenseless. There is a videotape of the proceedings, and it appears that the state, with little argument or debate from Mr. Eyman or interrogation by the court, gave the court an order which the court signed. There was no discussion of the elements of prejudice, for example. There was no discussion of the merits of the legal conclusion that Mr. Eyman could be characterized as a continuing political committee, and I saw no evidence there that these questions were properly litigated before the court or that the court really considered them.
Well, let me stop you there, Mr. Sanders. I want the record to reflect that this court devoted a great deal of time and thought and consideration to the state's motion for entry of an order of non-monetary sanctions. The court received the state's moving papers long in advance of its oral argument. So this was not a decision lightly made by the court, nor was it a decision made without consideration or without forethought. This court reviewed the allegations, the facts, and applied the law and the court rule. So the record should reflect that the decision entered by the court was not simply granting the state's motion without devoting any thought or doing any preparation prior to hearing oral argument on the state's motion. Thank you. Please continue.
Well, Your Honor, as you know, I wasn't there. I wasn't the attorney at the time, and I'm just trying.
I know, but when you say you've looked at a video that, in your opinion or your conclusion, leads you to argue that this court simply just granted the state's motion because there wasn't much argument made from Mr. Eyman or anyone on Mr. Eyman's behalf, that's not accurate.
All right. Thank you, Your Honor, for correcting me there. This trial that was just concluded, I think, sheds some light on that order for non-monetary relief. First, there was no prejudice demonstrated, which led to the entry of that order as per the testimony in this trial. Your Honor was, I believe, misled at the time of the order, but now we have a fuller record. And secondly, the court, the state seeks to apply this order beyond its own scope, which pertained to the $766,000. It does not pertain to anything beyond that, which the state wants to parlay into the trial right now. And it, in my view, on its face, the order doesn't control that. For example, in Exhibit 352, the state itemizes all kinds of expenditures, contributions and expenditures, which have nothing whatsoever to do with a ballot measure election. I
apologize, Mr. Sanders. I apologize for interrupting you. The court is now, my mistake. I looked at the clock. It's 12:04. It's afternoon. And I have obligations to other people, including the deputy clerk, the court reporter. So the court's going to interrupt closing arguments. Closing argument of Mr. Eyman. Mr. Sanders appearing on behalf of Mr. Eyman. Good morning, Mr. Sanders.
Good morning, Your Honor. Can you hear me okay?
I can, thank you.
Your Honor, I would like to start where I left off, discussing the court's non-monetary relief order of September 13th, 2019. Then I'll talk about some of the constitutional issues which not only underlie this whole case, but shape the statute and help us to understand the provisions of the statute. I'll talk about some of the specific points raised by Mr. Newman in his argument, and finally discuss the state's proposed penalties and injunctive relief. I appreciate the court providing time for extended argument here, but when I finish, I'm sure there'll be many topics that I have not addressed. So I'll try to keep that in mind, Your Honor, that this is not intended to talk about everything in the world. The court's September 13th, 2019 order for non-monetary relief stated Mr. Eyman failed to report $766,000 in campaign donations that he had a duty to report because he is a, quote, continuing political committee, close quote. This order denied Mr. Eyman the opportunity for a fair trial, or any trial for that matter, on this issue. It was in the nature of a default judgment. The court entered partial summary judgment based on its September 13th order. Based upon this order, the state now wants to fine Mr. Eyman over $1 million and subject him to reporting requirements as a continuing political committee for the rest of his life. I have addressed this topic before, to Your Honor. However, important new facts were disclosed in the trial. First, there was no specific prejudice shown to justify the order, just exactly the opposite. And secondly, the state seeks to extend the order beyond its scope to include even child support payments paid after the order was entered. To justify such an order, a case law provides there must be the presence of three different elements. First, there must be a willful and deliberate refusal to obey a discovery order. Second, the party's actions must substantially prejudice the opponent's ability to prepare for trial. And third, the trial court explicitly considered a lesser sanction. I'd like to focus my comments on the second criteria, that is, the party's actions substantially prejudiced the opponent's ability to prepare for trial. Substantial prejudice is always required to justify such an order. It is never presumed. There are a number of cases that stand for this proposition, among them Burnett versus Spokane Ambulance, 131 Washington 2nd, 484, Marina Condominium versus Stratford, 161 Warsh App, 249, and Rivers versus State Conference of Mason Contractors, 145 Washington 2nd, 674. These cases and other authority required a detailed record of the facts of prejudice and detailed findings so that there can be appellate review if necessary. In this case, the record to justify the order for non-monetary relief was the Perkins Declaration of September 5, 2019. He called it his first declaration, and the Attorney General motion of the same date. Near the end of my last oral argument, the court stated on the record that it took the matter very seriously and spent a great deal of time on it. The court stated, and I quote, "The court got the moving papers far in advance," close quote, of the hearing. So I would take it to be obvious the court not only had the declaration of Perkins and the motion of the Attorney General, but it studied them and it relied upon them. If my assumption is wrong, please, I invite the court to correct my misunderstanding. Here, the prejudice alleged was Mr. Eyman withholding the identity of donors based upon the Perkins Declaration of September 2019. The state's brief in support of the order on page 14 claims, and I quote, "These contributions go by the very heart of the state's case. Without the names of the donors, the state cannot ask them for the purpose of the donations." The claim was, of course, that Mr. Eyman was withholding the names of the donors. The declaration of Mr. Perkins at paragraph 32 states, and I quote, "The best example of how the Eyman defendants' long-standing misconduct in discovery has impaired the state's ability to prepare for this trial is their concealment of donor identities." Concealment of donor identities. This is the showing of prejudice which served as the basis for the court's order. However, at the trial, Mr. Perkins admitted that he had to cancel checks for all donors included in the $766,000 for a year prior to September 13th, 2019. He had the names, addresses, amounts, dates, phone numbers, etc. of each and every donor. I believe the court had the right to rely on his declaration under penalties of perjury and did rely on that declaration to accurately state the facts. However, now we know the declaration and motion were false. Names of the donors were not withheld from the state. It had them all. Every canceled check, name, address, phone number, amount, and date. Mr. Newman began his argument talking about how my client had been fibbing for the last 20 years. But I'm not talking about fibs. I'm talking about perjury. And it appears that the Attorney General, Robert Ferguson, suborned that perjury. The declaration of Perkins is on his pleading paper. He is an employee of the Attorney General, and he made this declaration on behalf of the Attorney General. So we're asking the court to do two things. One, find the truth, factually find that the statement is false and misleading. And secondly, deny the state the benefit of this order obtained through its own misconduct. We ask the court to vacate the September 13th order and give us a fair trial on the merits. If the court didn't know this was a lie before, it knows it now. Also recall our motion to reconsider the order of September 13th, 2019 was denied summarily by the court. But attached to that motion for reconsideration was an authorization for every single one of Mr. Eyman's bank accounts, the same ones that they already had, and more, and that Mr. Perkins used those authorizations to construct Exhibit 352, claiming that Mr. Eyman had another $71,000 in unreported donations that the state wants to fine him for. It is a lie that the state didn't know his donors, and now this court knows the facts. And I believe that it is also a fact that we spent 7 or 8 months supplementing interrogatories, but 100% of the state's case presented at trial had nothing to do with those supplements. As of September 2019, the state's discovery was virtually complete. Now I'd like to address some constitutional principles that should be recognized by the court in the construction of this statute and should ultimately govern the disposition of this case. Our trial brief and our response to the state's motion for partial summary judgment sets forth the constitutional concerns predicated on the First Amendment. We encourage this court to read and study as many of these constitutional cases as it can. Not only will this enlighten the court on the relevant constitutional principles, but it will demonstrate how this statute was carefully and narrowly drafted to avoid constitutional problems when it is properly applied. But the state urges the court to apply the statute in a way it has never been applied before, and contrary to its express language, rendering it unconstitutional if it is applied as the state proposes. The act is subject to strict or exacting scrutiny, according to Buckley versus Vallejo, 424 U.S. at 77 and 78. The only legitimate purpose of the Fair Campaign Practices Act in the context of ballot measures is voter education. That is, specifically disclosure of direct campaign contributions and direct electoral campaign expenditures. Buckley makes the distinction between direct campaign financing and issue advocacy. Issue advocacy and advocacy of a political result cannot be constitutionally regulated because it is core political speech. If the statute does not unambiguously limit itself to direct campaign finance reporting, it is unconstitutionally broad and unconstitutionally vague. Although properly read, it is limited to direct campaign contributions and expenditures, and that's how it should be applied. Buckley held that the statute can only be constitutionally applied, and I quote, to reach only funds used for communications that expressly advocate the election or defeat of a clearly defined candidate. This reading is directed precisely to that spending which is unambiguously related to the campaign of a particular federal candidate, close quote. Of course, here we're talking about a ballot measure, but the principle is the same. If the Fair Campaign Practices Act can be applied as argued to Mr. Eyman's fundraising for personal expenses, it is unconstitutionally vague and overbroad. It regulates core political speech, which cannot be constitutionally accomplished. Buckley emphasizes, and I quote, compelled disclosure in itself can seriously infringe on privacy of association and belief guaranteed by the First Amendment, close quote. The importance of private association was also the holding of NAACP versus Alabama. The right to anonymously associate and pool money is constitutionally protected. Here, the U.S. Supreme Court set aside hundreds of thousands of dollars in fines for refusal for the NAACP to disclose its members and contributors. Tim Eyman was held in contempt and fined for doing much the same thing. When the identity of the interveners was disclosed to the state, it threatened them with hundreds of thousands of dollars in attorney fees. Anonymity is important to the First Amendment. Reporting requirements are subject to strict scrutiny, and I'm looking at Utter versus BIAW, 182 Washington 2nd, 398. The only constitutionally sufficient interest is the substantial interest to disclose electoral campaign contributions and electoral campaign expenditures. There is no constitutionally sufficient interest to justify forced reporting of the finances of an officer of a ballot committee. And the statute on its face does not require that, although the state would. Recall, personal financial reporting is required of candidates pursuant to section, 235, who are required to file an F1 form, but not officers of a political ballot committee. The public has no interest in their finances. Probably the reason is that candidates continue in office and are subject to corruption, whereas officers of a ballot committee are merely sponsoring the measure. Once the measure is enacted, they have no further involvement with its enforcement and no discretion with respect to its enforcement. Aside from all that, even if Mr. Eyman were properly under the statute required to report, it is unconstitutional to subject him to unconstitutionally onerous reporting requirements. I'm looking at FEC versus MCFL 479 US 238. Mr. Eyman, as a continuing political committee, would be required to report every financial transaction for the last 8 years, thousands of them, and of course, all of them into the future. Moreover, he could not use his own money for personal expenses, that's barred by the statute, and would be required to hire a treasurer. He wouldn't be able to make any decision about how to spend this money. In short, he could not live without abandoning his political activism, which is the state's motive, not respecting the rights and following the law and protecting the rights of this citizen. That the state wants the court to misapply the statute is apparent from its oral argument. For example, Mr. Newman argued at 1 hour 25 minutes into his argument, quote, "If you are getting paid to allow you to do advocacy work, you have to report it," close quote. Absolutely not. That is core political speech, not an electoral campaign contribution. The statute doesn't require it be reported, and the Constitution provides Mr. Eyman a First Amendment right not to report it. And it provides the right of free association and anonymity to the donor as well. Now to reply, Your Honor, to some of the state's more specific points in its argument. Much of what I have said today and on January 7th pertains to and is a refutation of what the state stated in its oral argument. However, I will present some specific rebuttal on some specific facts. The state starts by talking about data bar and claims that data bar refunded money directly to Mr. Eyman and it was improperly reported. However, data bar is never mentioned in the state's amended complaint. It is not their claims are itemized in their amended complaint. Data bar is not one of them, and it is not properly before the court. Moreover, the record shows that the transaction was reported by the campaign treasurer, not Mr. Eyman. Nevertheless, Mr. Eyman tried to amend the report, but the PDC would not permit him to do so because he was not the treasurer. This illustrates the very first point in our argument, and that is that Mr. Eyman not only has no reporting responsibility under the statute, but he cannot report anything under the statute. The state spends quite a bit of time discussing matters that are outside the statute of limitations. Recall the statute includes March 2012, but nothing before it. But a lot of the state's arguments focus right there, prior to 2012. For example, the state tries to prove a 2012 kickback by citing a 2010 email suggesting a 50% signature gathering price bump in an earlier campaign, which never materialized. It never happened. The state mentions various gifts received by Mr. Eyman prior to 2012. But during that period, that is not only outside the statute of limitations, but people have a right to give Mr. Eyman anything they want. And unless it is an electoral campaign contribution, it need not be reported by anyone, not even a campaign committee. The state claims that Initiative 1185 produced a kickback to Mr. Eyman, but there is no proof of that. All campaign payments to Citizen Solutions were reported and properly so, every one of them. Apparently, the state argues they shouldn't have been reported as payments to Citizen Solutions, but rather as payments to Tim Eyman. I guess this is a novel, a bizarre approach to the case. It is not something that any rational campaign treasurer would even consider when reporting payments to Citizen Solutions for signature gathering. And I might add that this was not a phony or fake. $320,000 of the 320,000 signatures were actually gathered by Signature Solutions. And had they not been, the measure would not have qualified for the ballot. So the state claims that $308,000 of payments to Citizen Solutions were not to Citizen Solutions, but to Mr. Eyman. But we know that every penny listed paid to Citizen Solution was paid to Citizen Solutions. And we know that Citizen Solutions can do anything it wants with its money, and it need not be reported. The state goes outside the statute of limitations to talk about $270,000 payment requested by Mr. Eyman. This was never paid. The consulting agreement ultimately entered into in July of 2012 with the Citizen Solutions was not $270,000, but $308,000. There is no connection between the two figures. The state does not deny that Citizen Solutions was paid fair market value for the signatures it collected, however, tries to construct an argument it was paid too much. It compares gross amount paid to Citizen Solutions with the net amount paid to individuals on the street collecting signatures, but it fails to make the distinction or the disclosure that Citizen Solutions hired sub-vendors who in turn made a profit and then hired individuals on the street. So when we say an individual on the street was paid $1 or $1.50, that is not what Citizen Solution had to pay the sub-vendor or coordinator to obtain those signatures. But in any case, money paid by Citizen Solutions is not reportable by Citizen Solutions or by the campaign. If the Attorney General or the court thinks that that would be a nice provision, the argument should be addressed to the legislature, but we have to follow the statute as written. The state faults Mr. Eyman for raising money from potential donors, claiming he had more money than he was letting on. This, however, does not violate the act. The act only requires disclosure of campaign contributions and campaign expenditures. They were reported by the treasurer. There is no personal financial disclosure requirement for a ballot measure officer, only a candidate. A candidate fills out an F1 form pursuant to Section 235 of the statute. This is a big distinction in the Fair Campaign Practices Act between how they treat candidates and how they treat ballot measures. The state claims that Stan Long was a ministerial treasurer. However, the state has prosecuted ministerial treasurers such as Barbara Smith for improper reporting. Moreover, if Stan Long is a ministerial treasurer, that doesn't mean Tim Eyman has any reporting requirements whatsoever. They're just not in the statute. He is not a treasurer, ministerial or otherwise. The state claims that the consideration for the consulting contract of July 2012 in the amount of $308,000 was not for future work. However, all testimony from the parties is to the contrary. But even if it was an outright gift, that doesn't mean payments from Citizen Solutions to Mr. Eyman or Watchdog were campaign contributions. The Citizen Solutions was paid by the campaign for signatures, and obviously they got them. 320,000 of them were turned in. Citizen Solutions made a profit and can do anything it wants with its profit. There are no reporting requirements. There is no regulation on how much of a profit they make. There is no bailout if they don't make any profit. This is a free enterprise system, at least to this date. Period. The committee paid Citizen Solutions a final installment on July 6th to secure the delivery of these signatures. They paid Citizen Solutions what Citizen Solutions was owed. After that, the money was Citizen Solutions, and they could do what they wanted. The state claims that Mr. Eyman made a concealed loan to citizens in charge so it could make an in-kind contribution to the 517 campaign. It claims this is concealment contrary to Section 435, but that statute does not apply to loans. A donor need not disclose, a donor, that is citizens in charge, in-kind donor, need not disclose the source of his money or the maker of the loan. A campaign committee does not disclose the source of a loan to a contributor. This is the way the statute is written. That's how it's worked. That's how it's always been applied. The state claims a loan, by definition, is a contribution. Remember, they were talking about the contribution definition. They say the very first word is loan. However, you have to read more than the first word. Their claim is false, A loan for full consideration is not a contribution. That's in section 005, subpart 15, subpart A, subpart single I. This loan was 100% repayable. If there was a default in part on repayment, it is still a loan. A loan is a loan. The state claims the loan was paid back by, quote, other contributors to the 517 campaign, close quote. Not so. The loan was paid back by citizens in charge. Mr. Eyman asked his friends and supporters to donate to citizens in charge, hoping that they would get citizens in charge more money, which it could use to repay the loan. Repayments to Watchdog from citizens in charge had nothing to do with 517. 517 did not repay the loan, nor did donations to citizens in charge from Eyman, nor did donations to citizens in charge from Eyman's friends. The state claims that Mr. Eyman received concealed payments for political work, close quote. The state says checks labeled legal defense counted as political campaign donations if not deposited in Eyman's legal defense fund. However, the state takes the position that legal defense funds are not reportable at all. State Exhibit 352 recounts $71,000. The state says this is for, quote, political work, close quote. The statute doesn't require reporting donations for political work, only for an electoral campaign, and that is specifically contributions to and expenditures by an electoral campaign on the campaign. This approach by the state violates the First Amendment, and it is also outside the scope of the statute. Mr. Newman, in his argument, said, and I quote, I believe I've quoted this before, quote, if you are getting paid to allow you to do advocacy work, you have to report it, close quote. No, you don't. This is core political speech protected by the First Amendment. Mr. Newman goes on to another section of his argument, which he entitles Reporting Violations. The state wants the court to find Mr. Eyman a, quote, continuing political committee, not as a discovery sanction, but as a matter of fact. But note that the state rarely says continuing, close quote, when it talks about a political committee, because the state knows that Mr. Eyman cannot be characterized as a continuing political committee under the definition in the statute. And no individual anywhere ever has ever been so characterized. The statute requires an expectation of contributions to a campaign. There were none, as well as a organization which receives those contributions, which is part of the definition of continuing political committee, is plainly not met by a single individual. However, we agree that the September 13th order should be vacated, but there is no basis to conclude on the merits of Mr. Eyman's is a continuing political committee. He is not a ballot measure, and he is not an organization. He doesn't seek or spend money for campaigns. End of the story, period, full stop. Mr. Newman states, and I quote, what matters is he has expectation of receiving contributions to further electoral goals, close quote. However, that is not the statutory or the constitutional standard. Furthering electoral goals is very much like the problematic language discussed in Buckley that unconstitutionally swept in protected issue advocacy and was disapproved by the High Court. The state can't live with the statute as the statute is written. The court has to be particularly careful to read the words of the statute and understand the difference between what the statute actually says and what the state's argument is. The state says, and I quote, fighting for taxpayers is a political goal, close quote. That's at 1 hour and 30 minutes into the argument. However, fighting for political goals is not a subject of this statute, and it would be unconstitutional if it said that. There's a lot of people that fight for political goals. That doesn't mean that they have to report everything that they do in their life to the Public Disclosure Commission. Mr. Newman also used an interesting example from Eastern Washington, where Mr. Eyman apparently appeared at an outdoor meeting, and a friend of his passed the hat. And Mr. Eyman characterized what he said as, quote, "This collection is for Tim for all he's done for us over the years," close quote. This is not an election campaign contribution. It is not reportable. It is the essence of protected speech, and this illustrates the unconstitutional approach of the whole subject by the state. The state defends its position, saying that this illustrates the, quote, "expectation of receiving contributions," close quote. Sure, but not for an electoral campaign. Only that qualifies, not just a contribution for any purpose. There's another distinction the state fails to make about what the statute says. The state points out that there was a $308,000 consulting agreement, and that wants to fine Mr. Eyman that amount for entering into the consulting agreement. But that was Citizens Solutions paying its money to Eyman. It's not reportable. Then the state claims apparently campaigns should not have reported paying Citizen Solutions money for signatures. So how does that work? It did pay Citizen Solutions money for signatures, and the signatures were provided. Is the state saying that it should not have reported paying Citizen Solutions for signatures, but it should have just reported paying $308,000 to Mr. Eyman? That doesn't make any sense. It's counterintuitive. It's not in accordance with the facts of the case. If the money was for Tim and reported as such, that means Citizen Solutions would not even get the original contracted $1,050,000, since the bumps only accounted for $160,000, not $308,000. The state's theory doesn't make sense. Moreover, if Citizen Solutions wants to give Mr. Eyman $308,000 for any reason, that's its right, and it's not reportable. The state wants to fine Mr. Eyman $182,000 for its loan to Citizens in Charge, or I should say the watchdog loan to Citizens in Charge, claiming it was really loaned to 517. But those are not the facts proven in this record. It wasn't loaned to 517, and there was no duty on Watchdog to report this, nor a duty on 517 to report it either, nor a duty of Citizens in Charge to report the receipt of a loan. We know the loan wasn't to the campaign. We have the canceled checks to Citizens in Charge. All of this is a fantasy made up by the state in its convoluted approach to the case. The state wants to fine Mr. Eyman $832,000 for gifts from his friends as living expenses. This claim is unprecedented. It's bizarre. It is not supported by any precedent in this state or any other state ever. That is a continuing political committee issue, which I have previously discussed. The state wants to fine Mr. Eyman $1,250,000 for not reporting monthly as a continuing political committee. As previously discussed, he is not a continuing political committee and has no responsibility to report as a continuing political committee. The state wants to fine Mr. Eyman $23,000 for the data bar refund due to an alleged reporting error. But Mr. Eyman is not the treasurer. It is not in the amended complaint, and he can't amend and he cannot amend previous filings by the treasurer, although he tried. In total, the state wants to fine Mr. Eyman $2.6 million and then treble it. This is an outrageous sum, truly out of proportion to any like case under the PDC. Then Mr. Newman says Mr. Eyman is a very wealthy person who lives in a $1 million house on the golf course, and that people have a right to know how much he is making and his net worth. Well, let's start with what I call a fib. That's the word Mr. Newman used over and over again regarding Mr. Eyman, and it got on the front page of the Seattle Times, fibbing. Mr. Newman knows Mr. Eyman does not live in a $1 million house on the golf course. Mr. Eyman rents a condo in Bellevue, and his rent payments are listed in Exhibit 352. The house in Snohomish County is not where Mr. Eyman has lived since the state broke up his marriage. That's Karen's and the kids' house. Mr. Eyman's finances are well known now to the state. It gets monthly reports from the bankruptcy court. Mr. Eyman has about $40,000 in the bank, and from that must pay the state $10,000 every month to avoid default, as well as other listed creditors in the bankruptcy petition. When Mr. Eyman was on the stand, I attempted to go into some of his personal finances. The state objected, and the court sustained the objection. Mr. Eyman's financial shape is in reality untenable, and Mr. Newman knows it. As to the claim that the public has a right to know about Mr. Eyman's personal finances, there isn't any. There isn't any right to know that. Mr. Eyman is an officer of a political committee. He is not a candidate. Unlike a candidate, he need not provide any personal financial disclosure according to Section 235. He need not file an F-1 form. For the reasons I outlined last time, personal financial disclosure is not required from a ballot committee officer because the public has no legitimate interest in that information. But the state doesn't agree with the statute and wants to say it is something it isn't. I suggest that the remedy for the state is the legislature, not this court. A further word about penalties. The penalties urged by the state are maximum penalties. The statute sets no minimum penalties. We don't think any penalties are appropriate at all as a matter of law. However, if the court were to consider penalties, it should also consider Section 750, Subpart D, Subpart XIII, which directs the court to consider penalties in factually similar cases. The penalties argued by the state are grossly disproportionate to those in similar cases. We got into this earlier with respect to exhibits, and it was my understanding at that time that if the court were to find liability, we would take this up separately. However, I will give you two examples of similar cases. These two examples are relevant because they involve individuals, not massive corporations, and they involve dishonesty. The fines in these cases are a fraction of what is being sought in this case. There was no injunctive relief to speak of imposed in these cases, in contrast to the AG's announcement that he would like to wage something like World War III against my client. First example, the Aaron Reardon case. Mr. Reardon was the former Snohomish County executive and was fined $4,200 by the PDC for several reasons, including the use of county resources to campaign and raise money, the use of taxpayer-funded staff on county time and compete to harass officials he designated as his enemies. The case was investigated 3.5 years by the PDC. The PDC chairwoman, Katrina Assay, told the Everett Herald, and I quote, "I feel like this is one of the most I feel like this is one of the most egregious cases I've seen. Like I said, there was a $4,200 fine, no equitable relief. Another case, which I think is analogous, is Moxie Media, because it involves roughly the same amount of money as our case, that is $300,000. This case involved a successful false flag campaign to deceive voters into rejecting an incumbent candidate. The campaign intentionally concealed the source of its contributions to make it appear it was from one side when it was in fact from another. The deception caused the defeat of an incumbent. The fine was $110,000 with no ongoing limitations on political activity, despite lying about sources of their financing to successfully influence an election and deceive voters, who were in fact deceived. The only equitable relief granted by the court was mandatory training. Lastly, the state argues for injunctive relief. Before we discuss this, I think the court should recognize that characterizing Mr. Eyman as a continuing political committee is something different from injunctive relief. This injunctive relief, the state wants to add on top of that. If he were characterized as a continuing political committee, he would have, through his treasurer, he'd have to hire a treasurer. He couldn't do it himself. He would have to hire a treasurer who would report all income to the political committee and all expenditures by the political committee. There are no exceptions. There's no exception for a W-2 or whatever. Everything that goes into the committee and everything that goes out of the committee has to be reported. And none of that can be used for personal expenses. That's also in the statute. In fact, it's part of the government's claim regarding the receipt of the $308,000. So characterizing him as a continuing political committee creates an impossible situation for Mr. Eyman. He simply couldn't live. But now they want to add on top of that an injunction. This injunction would put Mr. Eyman under this court's supervision for the rest of his life, unless he abandons all political advocacy, which is obviously his First Amendment right to participate. The state seeks to enjoin him from, quote, directly or indirectly as to why someone should donate to a campaign committee or how the contributions would be spent. This is as broad as it is vague. Any promotional speech on the part of Mr. Eyman would be subject to sanction and would be chilled. He cannot do business, according to the injunction, with any vendor, quote, directly or indirectly, who provides or might provide services to an associated political committee. These are all free speech activities that the state would like the court to enjoin Mr. Eyman from participating in. The state wants an injunction saying that he must report all income of whatever nature or source unless from a W-2 employer. So I guess that the state's position is Mr. Eyman cannot seek self-employment without reporting all aspects of that self-employment. The state says that he should be permanently enjoined from, quote, managing, controlling, negotiating, or directing financial transactions of any kind for any committee, close quote. So I guess he can't negotiate a printing contract or a signature gathering contract or change phone numbers or do anything. He's in a straitjacket. You cannot participate in a free society with those kind of restrictions. The list goes on and it goes on, and I will not attempt to summarize all of it. There's just too much there. Such an injunction would eliminate his free speech activities and eliminate his ability to meaningfully participate in any ballot measure campaign, which is exactly what the Attorney General wants. This is in combination with reporting every financial transaction associated with characterizing him as a living, breathing, continuing political committee. And it leaves him no room to breathe to participate in a free and democratic society. And I believe that we see references to no room to breathe in cases like NCAA or NAACP versus Alabama, that freedom means that you have to have freedom to breathe when you're exercising your free speech rights. Here, there is none. So, in summary, the case is designed to eliminate Mr. Eyman as an advocate for less taxes, smaller government, and a free society. It will put him in virtual jail with this court as the jailer, with unending court hearings in the future to supervise every aspect of Mr. Eyman's life. In conclusion, our statute simply does not support the state's claims. As a reporting statute to guide men and women of common understanding, it must be applied in that way as well. This is a statute which exists in the heart of the First Amendment political advocacy and must be applied as clearly written in a common sense way. It is not a statute which deals with original and bizarre theories, but rather simple reporting. That is anything but the state's case. It requires campaign reporting of election contribution and election expenditures. That's it, only it. Only the treasurer has the reporting responsibility. Mr. Eyman is not a treasurer, and he need not and could not report anything. Stan Long reported everything he was required to report. The state's claim regarding 2012 reporting is meritless. So to the proposition that Mr. Eyman is or could be a, quote, continuing political committee cannot be squared with the requirement that contributions be solicited only for actual election campaigns, not individuals active in the political process, which is what Mr. Eyman is. This is not a case which tests whether the court agrees on every point or every action with Mr. Eyman, but rather if he has clearly violated the law as written. He didn't. The state's claim should be dismissed with prejudice, and Mr. Eyman should be awarded his reasonable attorney fees pursuant to Section 780. Thank you very much, Your Honor.
Thank you, Mr. Sanders.